So, every case is different. Facts are extremely important in determining the outcome. And again, let's say you kill somebody that's in your home, right? So now you are going to be brought up on charges of murder. Can the ADA prove beyond all reasonable doubt the elements of murder? Is it going to be first degree? Is it going to be second degree? Your argument is going to be self-defense, right? Certainly depends on the state, Fifi, and it also really depends, because laws are different in every state, and it depends on it definitely depends on the fact pattern. Definitely depends on the fact pattern. Depends on the fact pattern. Okay, so I know we can talk about a lot of different scenarios, but I'm going to just move on because it's 7:47, and I did want to get through a couple of things. So next thing I want you to know, you need to know the 4th, 5th, and 6th Amendment. I always test on those. I'm going to go over them one at a time, but you need to put it down in your notes that you need to know 4th, 5th, and 6th Amendment. So 4th Amendment, again, you've heard this if you've ever watched any of these law shows. It protects individuals against unreasonable searches and seizures, right? So I like to always give a couple of these examples. If a police officer comes to your door and they say, hey, there was a robbery in the building or in your area or on your block, can we come take a look to see, if, can we just come inside and kind of take a look and talk to you maybe a little bit more? And you say, sure. Now, when they enter your place, let's say you had illegal items that are in plain view. Can you now be arrested for these illegal items?
Wait, so if you call the cops for something,
I don't think so.
They saw it.
You didn't call the cops. They knocked on your door. They said there was a robbery down your block. They just wanted to come in and talk to you. They go in. They see some legal stuff on the table in the kitchen.
Yeah. Like they don't have a warrant for it, right? So they can't arrest you, no?
But you let them in your house though, so technically they weren't searching, they just saw it. So
let them in your house. You gave them permission to enter your home, and the items were in plain view. That's not considered an illegal search. You gave permission, they entered, they saw it. They can't arrest you. Let me give you fact pattern number 2. You live with a roommate. You have a room, your roommate has a room. The roommate is not home. The door to their room is slightly ajar. It's a little open. Cops knock on your door. They say, hey, there's been a robbery down the block. Can we come in and search the place and talk to you a little bit? We have some questions about some missing items from your neighbors. You say, sure. They come in, they're walking around, you're with them. They open your your roommate's door, and they see some illegal items, gun, drugs, whatever, on their nightstand. Will your roommate, is that considered an illegal search?
Yes, because the person in question is not there to give their permission for the search.
Okay, so you're saying yes, it's illegal. Anybody else?
Is it a vicarious liability?
Could be. Good use of that. Could be. Somebody said, no, it's not illegal. Fifi, you have a hand up. I don't know if it's old or new. Does it depend on who owns the home?
it was new, but never mind.
Okay. In the fact pattern I gave you, the door was slightly open. You had somebody that had control and dominion over the apartment that let the cops in. The cops position, the ADA, when they charge this individual, the roommate who is not there, their position is going to be, we asked permission to search the apartment. We were given permission. The door was not closed. We went in, and we looked. There was nothing to stop us. We didn't need search. We had permission. That's very much could be. So that one, it could go either way. But most likely it's going to be okay for them to seize that and arrest this roommate. Okay, and okay, perfect. The door is locked. So that was going to be my next switching up a fact pattern. If the door was locked and they broke the door, same everything else, they broke the door to enter, then they saw the illegal stuff, that is not a legal search, and that would not be a legal arrest, and any item seized would be thrown out as a product of an illegal search because they had no permission to enter and they had no warrant to seize the items.
Professor, if I were the one who opened the door, right, and then I closed my roommate's door, can I tell them that that's off limits because it's not my
Correct.
space?
You can, yeah.
Okay, great.
Somebody else wrote something here. Let me just put that, blah, blah. It says about not locked doors. So you lock the door, you don't want them in. Yeah, if you lock the door and you prevent them, absolutely, that's totally fine. So when you have warrants, a warrant is a document signed by a judge that lets the officer search in certain areas. But when an item is in plain view, even if it's not on the warrant and the cops see it, then they can take it. Okay, so your Fourth Amendment is what? It protects individuals against unreasonable searches and seizures. Okay, that's Fourth Amendment. Your Fifth Amendment, you've heard this one again. I think this is a lot of fun. It protects against self-incrimination, right? I plead the fifth. I plead the fifth. What does that mean? I don't have to testify against myself. I don't have to testify against myself. Now, I spoke about it a little while ago. What happens, even though the legal system presumes that somebody is innocent until they are proven guilty, what happens, or what do you think if you were a juror and you're sitting on a murder trial, robbery, burglary, whatever it is, and the defendant doesn't take the stand? What do you think? What are you thinking at that point?
Can you repeat the question?
Sure. Let's pretend you are a member of the jury and you're listening to a case where you have a defendant who is accused of murder, robbery, burglary, whatever it is. And they decide not to take the stand. They don't want to go up on the stand. They don't want to answer questions. If you were a member of that jury, what do you think of that person? What would you think? What conclusions may you draw?
Be like suspicious or something.
Guilty.
Suspicious, guilty. They got to be guilty. Why are they not taking the stand and defending their good name? Why are they not talking about their side of the story? It's good. You give them the benefit of the doubt. You're one of a few, Fifi. Most students automatically said, they're guilty, right? Human nature, unfortunately, it's like, oh, why are you not going up there? Even though it is your right not to go up there, because the burden is on the ADA, the burden is on the government to prove that an individual is guilty beyond all reasonable doubt. Maybe somebody threatened them, but do you want to hear it from them? Don't you want to hear their side of the story? Why they did what they did? So again, I'm kind of telling you what it is, right? Like what the Fifth Amendment is. But now when you apply it to real life, even though you have the right not to go up on that stand, sometimes your peers of the jury, they may draw these conclusions against you by exercising that right that you are granted. Okay. All right. Now we're going to go on to the Sixth Amendment. The Sixth Amendment says there's a bunch of things that it says federal government shall provide speedy public trial. You can confront your witnesses, but the more important thing that I want you to know is that you get the assistance of counsel. You get the assistance of counsel. Not all the time, depends on the case, right? So if you're suing somebody in a car accident, you don't have an automatic assistance of counsel. You don't get a pro bono attorney. You don't get an attorney to, represent you in a car accident. But when you are being accused of a crime where your life and, liberty may be taken away, if you cannot afford an attorney, one will be provided for you. That's your Sixth Amendment right. Okay? So we just covered everything I need you to know for criminal law for this case, for this class, for this, for tonight. Does anybody have any questions? How are you guys holding up? So far, so good? Alive?
Yes.
Okay, great. So according to our syllabus, we're still supposed to go over chapter 7, which also includes it's torts, and then, we do a couple of cases. I know it's the first night of class, so I try to go easy so as not to scare students the first night. If you're doing okay, we can keep going, or we can cover this material next week. It's up to you. Who wants to keep going? Give me a show of hands with your fake yellow hands. Anybody want to keep going? 2. Okay, now put your fake hands down. Oh, 4. Okay, good. We have 44 students. So at 4 said yes. 5. Okay, put them down. How many people want to make the stuff for next week? Next week's people. Okay, 7. And I guess like 30 of you don't really have one way or the other. So I have no problem breaking at this point, only because this is now criminal. Next week we shift to civil. So you know what? I'm going to give you a couple of things. We're not going to go over the entire chapter 7, but I do want to tell you about this. I'll end with this. When we talk about civil cases, now this is a write it down moment. The standard of proof in a civil case is preponderance of the evidence. So whenever we talk about the standard of proof in a civil case, we're talking about preponderance of the evidence. What does that mean? When we talked about criminal law, we said it's beyond all reasonable doubt. And we said if you were to put it on a scale of 1 to 100, it would be between a 90-95% you have to show guilt. When we talk about civil cases, which are when you sue one person, suing another person, usually for monetary benefit, preponderance of the evidence, if you were to equate that to a number scale of 1 to 100, what do you think that number would be? Somebody said 50. 51.
100.
Not 100. It's actually 51. So when we talk about civil cases and we talk about the burden of proof, think of it as 51, showing you're more likely than not. You're more likely than not. That's all you have to show, that your position when you're trying to sue somebody for something, a car accident, a contract dispute, medical malpractice, bike accident, slip and fall, any of those things. When you sue somebody for money like that in a civil case and their life and liberty is not hanging on the line, you just want to show more likely than not that your version of the events is correct. and you have to prove to the court more likely than not that you are correct. So I like to say it's 51%. It could even be considered 50.1. As long as just a tiny bit more than the other side, then you will win. Okay, so keep that in mind for our next sessions, because now everything from this point on for the ended semester is basically civil law. And so you don't have that high burden of proof. It's just more likely than not that somebody is correct. Okay. Does anybody have any questions of the material that we covered so far? Because we're not ready to get off yet. I want to give you some pointers for the class. Does anybody have any questions? Okay, here's the thing, and I forgot to mention this. So during class, I ask questions. And if you look at your syllabus, like for the, I was going to ask about Philip Morris v. Williams and White v. Samsung Electronics. When I write a case in the syllabus, I expect you to know it. And what's going to happen is I always ask who wants to tell me about, such and such a case, the cases that are on the syllabus. Somebody needs to be prepared. There's 44 here tonight. This class might have over 50 students. The only assignment I give you is to read. If I ask for somebody to tell me what a case is about and no one volunteers, I automatically test you on it and I don't tell you anything about it. So I'm not going to tell you anything about it. And you're going to be tested on it. Because the only thing I ask for this class is that you read to prepare for class. If you're not even going to read, I'm not, that's what you got to do. So I'm stopping now because I don't want to ask who read Philip v. Morris and ready to give us a summary. You don't have to have every single, fact pattern. You have to have the gist of the case. Who's suing who over what? What's the outcome? What happened? You're going to read a case and you're going to tell me about it. You're going to tell the whole class. There's some cases I test on, a lot of cases I test on throughout the semester, because I believe that cases are an illustration of the law. So especially when I tell you I like this case, I test on it, definitely know it. Okay? Does anybody have any other questions? So I'm going to update the class attendance sheet. And then when I take attendance next week, hopefully it'll be more accurate. I'm going to tell you which cases I want you to know, like when I tell you to write something down. Whether or not I test on it at the end, we'll see. But usually I will not test you on a case that I did not go over in class and like that we did not review unless nobody read. So what happens is I ask for a volunteer who wants to tell us about Philip v. Morris, right? For example. So I have one person that volunteers and tells me about the whole thing. Then I could potentially ask, does anybody, if I felt that there was something missing, I'll ask for anybody else. Does anybody else want to add anything to that case? But I need to have some meat and potatoes, right? Give me the bulk of that case. So if you want to set up a group with your classmates, a couple of students have a study group and say, all right, we're 5 of us, 10 of us, whatever it is, I'm going to be responsible for this case. You be responsible for this case. That way you can guarantee somebody's always prepared for class. That's fine. Or you can just read the material because it's not that much. All right. Any other questions?
What case is it that you want us to read again?
On the syllabus. The cases that are on the syllabus are the cases you're responsible for.
Okay, thank you.
So sometimes the textbook has other cases. I don't care about them. It's whatever I wrote in the syllabus that I want you to know. And then within those, I will tell you when we're going over it, which ones I really want you to know. Because there are some cases, I'll tell you right now, looking at the syllabus, like Philip v. Morris, White versus Samsung, I always test on those. Hold on, let me see here. Palumbo v. Newkirk, I don't think I test on that one that much. But if nobody knows about it and nobody says anything about it in class, like nobody was prepared on it, then I will test on it. But when we go through the semester, I'll tell you, this is a good case I want you to know. Yeah, so basically that's it. Okay. Any other questions? Going once? Going twice? Okay, well, have a great night, and I will see you. Let me see when our syllabus. So then we have some days. Let me see. Monday. I will see you September 13th. Philip Morris is one of them, but it's not the only case. Here's a link to group me if anybody wants. I don't know what that is. Okay. All right. Have a good night, everyone.
Have a good night, Professor.
Good night.
Thank you. Good night, Professor.
Good night.
Have a good night, Professor.
Good
Good
night,
night.
everyone. Good night.